This meeting is called to order. Mr. Trobman, has anyone signed up for public comment? Thank you very much. Good morning, Ms. Miller.
Good morning, sir.
How are we today?
Very well, thanks.
Oh, good, good. How about agenda item 3? Do we have any cases to consider?
No cases.
No reconsideration. Then on agenda item 4, tax liability cases, I think we do have one tax case on docket 40.
Yes, sir. It's one case, TD-21-020-0721. Commissioner Demerson?
I disagree with the staff recommendation and would rule that the nail technicians are not in employment since they rent their workspaces from the company, pay their own expenses, are not trained by the company, set their own prices and discounts, determine their own hours, resolve their own customer complaints, and may work freely for other companies.
I agree with staff's recommendation.
Agree with staff recommendation.
Thank you. Yes, sir.
No fair housing cases on agenda item 5.
Correct. No cases.
On agenda item 6, no wage claim cases are pulled for additional discussion on docket 40.
Correct. None pulled for discussion, but you should have received the wage claim short form dissent list for docket 40.
I move we accept staff recommendations on the remaining wage claim cases on docket 40.
I second the motion except for those cases on which I am dissenting as reflected on the wage claim short form dissent list for docket 40.
Motion passes with the exceptions noted.
Thank you.
Thank you. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 40. Please proceed when you're ready.
Case 2598352, Commissioner Demerson.
We should modify the appeal tribunal decision and not contest the good cause finding. Regarding the job separation, the payment was discharged for taking a picture of, thereafter circulating the pay stub of his colleague with other members of the employer's staff. The payment through this unauthorized action jeopardized his colleague's basic privacy rights. Furthermore, the claimant's intentional act placed the co-worker's personally identifiable information in peril. As such, the appeal tribunal should be modified. The claimant had good cause for his non-appearance, misconduct, no chargeback, adequate employer response. In the alternative, if my fellow commissioners disagree, we should conduct a rehearing in this case. The available evidence suggests that the co-worker's personally identifiable information could have been compromised through the claimant's conduct. Hence, a rehearing is warranted to further develop the record about the extent of the claimant's dissemination of personally identifiable information.
The AT decision should be affirmed. On the good cause issue, the claimant provided credible testimony that he did not receive the notice of telephone hearing prior to the AT1 hearing. On the separation, the claimant sent an employee's pay information to another coworker. The employer had no policy prohibiting this conduct, and the discussion employee pay is a protected labor practice. The claimant's actions, therefore, did not constitute misconduct connected with the work. Affirm the AT, claimant had good cause for non-appearance, no misconduct chargeback.
Affirm the AT, claimant established good cause for AT1, no misconduct chargeback.
Short form dissent.
Yes, sir. Commissioner Demerson?
Case 2599145, Commissioner Demerson.
The appeal tribunal decision should be reversed. The employer presented credible testimony that it was prevented from attending the appeal hearing due to an important emergency meeting at the company. In its timely petition to reopen, contained in the file documents, the employer representative explained that she was unable to attend the appeal hearing due to an unscheduled mandatory managers meeting that was occurring at the same time. The employer attempted to call in for the hearing after the mandatory meeting had concluded, but were too late to participate. Since the employer was prevented from attending the hearing due to an unscheduled emergency meeting as opposed to something foreseeable, it should be found that it had good cause for its non-appearance. Accordingly, we should reverse the AT decision. The employer had good cause for its non-appearance. Resubmit. In the alternative, I would also support a vote to rehear the case for the employer's appeal to the commission to be entered into the record, since it explains that the emergency meeting was to contemplate a second round of COVID-19 layoffs, that the employer's representative present was critical at the emergency meeting since she was responsible for all the company's finances and human resources issues, and that due to the severity of COVID at the time, the emergency meeting was neither foreseeable nor preventable. As such, we should rehear the case to enter the employer's appeal to the commission into the record.
The decision should be affirmed. The employer in this case chose to hold an internal staff meeting rather than attend an appeal tribunal hearing. The employer had complete control over the scheduling of staff meeting and has failed to produce any evidence that it is necessary to hold a staff meeting rather than attend a hearing. Furthermore, the representative and witness who called in late for the first hearing was not the only person who could appear on behalf of the employer, as evidenced by the fact that she did not appear for the reopened hearing. The employer failed to establish good cause for his non-appearance at the first hearing. With regard to the underlying issue, the claimant complained about the owner's anger management issues. The employer's failure to resolve the claimant's legitimate complaint provided him good cause connected with the work for quitting. Affirm the AT, no good cause for the employer's non-appearance, no voluntary leaving, chargeback.
Affirm the AT. Employer did not establish good cause for AT1, no voluntary leaving, chargeback.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case 2601085, Commissioner Alvarez.
I agree that the claimant had good cause for missing the first appeal tribunal hearing and named the correct last work on his claim. Regarding the separation, the AT decision is not supportable. The claimant's assignment ended when his client left the named employer. As testified by the employer, the claimant worked for the named employer and another legal entity, both of which were part of the same company. The named employer offered the claimant additional work which conflicted with the work he was performing for the associate entity. As the work offered conflicted with the work the employer's associate entity already had in performing, the offer was not a genuine offer for additional work. The claimant was effectively laid off when the employer failed to make a genuine offer of additional work. Modify the AT, good cause, correct last work, no misconduct, chargeback, void, adequate response.
The appeal tribunal decision should be modified. I agree that the claimant had good cause for his non-appearance and that he named the correct last employing unit. As to the job separation, the employer, a home health care agency, offered the claimant additional work. But according to the claimant's fact-finding statement, he had to turn the employer's offer down because it conflicted with his other job. The latter is a personal reason which does not constitute work-connected cause to quit. As such, we should modify the AT decision. The claimant had good cause for his non-appearance. The claimant named the correct last work, voluntary leaving, no chargeback, and sever the adequate response issue.
Modify the AT. Claimant established good cause for AT1, no misconduct, chargeback. Claimant named the correct last work, void, adequate response.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case 2721552, Commissioner Alvarez.
The AT decision should be reversed. The claimant gave the employer notice of her intent to resign in late October of 2019. However, at the employer's request, she continued working essentially through the end of the employer's school term until she could find a replacement for the claimant. Since the claimant worked for an indefinite time period and only stopped working at the employer's initiation once a replacement was found, the employer initiated the separation. The claimant was let go at the employer's convenience. Reverse the AT, no misconduct, and bill reimbursing employer.
We should affirm the AT decision. The claimant had resigned for the purpose of caring for her young child. The claimant's testimony had detailed that reasonable alternative care was available to the claimant on or about the time of her separation. Per Section 207.045 of the Act, since reasonable alternative care was readily available, the claimant's disqualification arose from personal reasons not related to work. We should affirm the AT decision, voluntary leaving, reimbursing employer not billed. I agree that the case be referred for PUA eligibility. In the alternative, the Commission should remand the case to the appeal tribunal decision. The hearing officer failed to admit any of the hearing documents into evidence. These documents are relevant and material and should be considered before making a decision in this case. As such, we should remand the case for further admission and review of these records.
Affirm the AT. Voluntary leaving, reimbursing employer not billed. Memo to determine PUA eligibility.
Short form and again, referral for PUA consideration.
Yes, sir, short form dissent, and we will send that memo.
Case 2803519, Commissioner Alvarez.
The decision is not supportable. There are two received stamps on the present appeal, and the envelope has been lost. Review 32E4 controls in this situation, and it states that appeal is considered to be received 3 days prior to the date received by the agency. The AT incorrectly counted from the date received by the appeal tribunal. 3 days prior to September 15, 2020, date received stamp is September 12, 2020, which is a timely appeal. The claimant's appeal should be deemed timely. Claimant appeal and resubmit.
The appeal tribunal decision should be affirmed. The claimant filed her appeal beyond the applicable deadline to do so. The claimant stated that she filed after the deadline because she lacked printer ink. This is a good cause reason for filing late, and since there are no good cause exceptions to the timeliness rules, the claimant's appeal should be dismissed, leaving the underlying decision in full force and effect. We should therefore affirm the AT decision, untimely claimant appeal, voluntary leaving, no chargeback.
Reverse the AT, timely claimant appeal, resubmit.
Case 2809952, Commissioner Alvarez.
The decision is not supportable. UBS does not show the claimant as signed up to receive electronic correspondence, and the use of records that have not been disclosed to the claimant is a violation of due process. Given the obvious anomaly in the electronic record and the fact that the claimant did not view the determination until January 2021, her appeal should be deemed timely. Timely appeal and resubmit.
The appeal tribunal decision should be affirmed. The claimant filed her appeal beyond the applicable deadline to do so. This was due to the claimant being locked out of her UBS account. There does not appear to be evidence that the claimant being locked out of her account was attributable to the Texas Workforce Commission. As there are no good cause exceptions to the timeliness rules, the claimant's appeal should be dismissed as late with the underlying decision left in full force and effect. Accordingly, we should affirm the AT decision, untimely claimant appeal, voluntary leaving, no chargeback.
Affirm the AT, untimely claimant appeal, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case 2818623, Commissioner Alvarez.
The decision is not supportable. The claimant was not asked about the final incident at the appeal tribunal hearing. The case should be remanded to obtain testimony from both parties about the final incident. Remand.
I agree. The case should be remanded. The claimant did not address and was not questioned concerning the employer's allegation that led to his removal from the assignment in question. Since this is what caused the claimant's job separation, the case should be remanded to gather testimony from the claimant regarding the final incident.
Remand.
Thank you. We have a unanimous decision.
Case 2831722, Commissioner Alvarez.
The decision should be modified. Only the claimant provided sworn testimony and evidence. His testimony established that the employer ceased taking any measures to prevent the spread of COVID-19. The employer encouraged workers to work sick, and there were many workers exhibiting symptoms in the workplace. The claimant spoke with his supervisor about the lack of preventative measures and was told that the management did not intend to change their policy. The employer's failure to resolve the claimant's legitimate complaint provided the claimant good cause connected with the work for quitting. Modify the AT, no voluntary leaving, no chargeback, disaster.
I agree with Commissioner Alvarez, disaster.
Okay.
Agreed.
Thank you. We have a unanimous decision, and no voluntary leaving, no chargeback, disaster.
Case 2840095, Commissioner Demerson.
We should modify the appeal tribunal decision. On or about the time of the claimant's separation, the claimant, her daughter, and her partner was sick, likely due to COVID-19. The claimant lacked child care and was furthermore tasked with providing care for her partner. Since the preponderance of the evidence indicates that the claimant's separation was a result of her medically verifiable illness and the medically verifiable illness of her child, the claimant should be qualified for benefits and the employer's account should be protected from charge. Therefore, we should modify the appeal tribunal decision, no misconduct, no chargeback, MVI, void the adequate response issue. In the alternative, we could modify the appeal tribunal decision, The available record indicates that the claimant's separation was a direct result of COVID-19 pandemic. Since the claimant's separation arose from the effects of the pandemic, the claimant should be qualified for benefits and the employer's account should be protected from charge. Therefore, we should modify the appeal tribunal decision, no misconduct, no chargeback, disaster, avoid the adequate response issue.
I would agree with Commissioner Demerson and also include their disaster protection.
Thank you, sir.
Agree.
We have unanimous decision. That disaster pay and protect and void the adequate response.
Case 2849302, Commissioner Alvarez.
The AT2 decision should be reversed. The claimant provided credible testimony and a written statement in her appeal that she called before the AT1 hearing but was not connected with the receptionist until after the start time. Her call was then registered 5 minutes after the hearing start time. The hearing was already closed when the claimant's call was registered. Reverse AT, claimant had good cause for the non-appearance at AT1, resubmit for merits.
The appeal tribunal decision is fully supportable. Regarding good cause, the claimant misread the notice and was expecting a phone call without first registering for the hearing. When she realized what she needed to do, TWC records indicate she called in 5 minutes late. Thus, under commission precedent, the claimant failed to establish good cause for missing the AT1. As to the job separation, the available record indicates that the claimant may have had some concerns about her working conditions, yet she quit effective immediately without raising her concerns with the employer prior to quitting. Because the claimant did not provide the employer an opportunity to address her concerns, the claimant quit without good cause connected with the work. Accordingly, we should affirm the AT decision. The claimant did not have good cause for a non-appearance, voluntary leaving.
Reverse the AT. Claim established good cause for AT1. Resubmit.
Thank you. We will resubmit the case.
Case 2864603, Commissioner Demerson.
We should reverse the appeal tribunal decision. The employer had requested the claimant's help to manage the influx of unemployment claims. The employer, hoping to properly accommodate the claimant, had offered to hire another individual to assist the claimant. Furthermore, the employer had planned to outsource a large portion of its IT needs to free up work for the claimant. The claimant, per his employment agreement, was aware that he could be tasked with performing additional duties assigned by the company from time to time. The agreement noted that the claimant's job duties included coaching, counseling, and disciplining employees. Though the claimant alleged that his job duties did not involve matters related to HR, the employment agreement established that the claimant was aware that his job duties could involve matters related to HR. The employer's request for help with the unemployment claims was not outside the scope of the claimant's job duties. Thus, the claimant did not have good cause to quit. As such, we should reverse the appeal tribunal decision, voluntary leaving, no chargeback, adequate employer response.
The decision should be affirmed. The claimant worked as an accounting manager and also performed IT duties. The employer requested that the claimant start processing unemployment claims. This was an HR function and not within the claimant's listed job duties. As such, the claimant had good cause to quit instead of accepting the change to hiring agreement. Affirm the AT, no voluntary leaving chargeback.
Affirm the AT. No voluntary leaving. Chargeback.
Short form dissent.
Yes, sir. Commissioner Demerson.
Case 2881369, Commissioner Alvarez.
The decision should be reversed. The office manager initially testified in the AT hearing that the claimant was discharged. The response, the notice of initial claim, was signed by the office manager and also states that the claimant was discharged. The office manager's contradictory testimony in the middle of the hearing that the claimant quit was not credible. Both parties provided sworn testimony that the claimant was discharged and the job separation should be analyzed as a discharge. Testimony clearly established that the claimant was not able to perform to the employer's satisfaction. Her inability to perform to the employer's satisfaction was not misconduct connected with the work. Reverse AT, no misconduct, chargeback, void adequate response.
We should modify the appeal tribunal decision. On the claimant's last day, the employer met with her to discuss the employer's expectation that the claimant's work performance dramatically improve. Although the employer had no intention of discharging the claimant at the time, the claimant interpreted the employer's statement to mean that she was being terminated right then and there. The claimant acknowledged she was not told that she was fired, yet did not return to work. By not clarifying her status and failing to return to work after the meeting, the claimant is considered to have quit without good cause connected with the work. Accordingly, we should modify the AT decision, voluntary leaving, no chargeback, sever the adequate response issue.
Modify the AT, voluntary leaving, no chargeback, sever adequate response.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case 288848, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The claimant quit her job due to dissatisfaction with her supervisor. While the claimant stated that she spoke to her supervisor about her concerns, she also stated that she did not speak to anyone else with the employer about her concerns. The claimant attributed her reluctance to notify anyone else with the employer due to a fear of retaliation. However, fear of retaliation is one of the main reasons why employers institute grievance and complaint procedures at their companies. Here, the employer stated that it has an HR department and that employees are told about its existence when hired. The employer continued by adding that it also had a hotline that employees can call to report problems or an anonymous online system where they can report problems. In light of the multiple methods that the employees could report their complaints, the claimant denied the employer an adequate opportunity to address her concerns. The claimant, therefore, quit without work-connected good cause, and we should reverse the AT decision. Voluntary leaving, no chargeback, adequate employer response. Designate the employer as a party of interest.
The decision should be affirmed. The claimant supervisor was not scheduling employees correctly and causing confusion regarding what work was to be performed. The supervisor was also assigning more work than could be completed. In the final incident, the supervisor called the claimant late at night to complain about another employee and blamed the claimant for the other employee's failure. The supervisor had a habit of assigning blame to the claimant for other employees' mistakes. Due to these ongoing issues, the claimant was forced to resign because the situation had become unbearable. The claimant did not complain to HR because her supervisor had told the claimant that all complaints had to go through the supervisor. The supervisor also said that an employee who complained had been discharged. After the claimant's resignation, the employer's discharged the supervisor due to her ongoing mismanagement. The claimant established good cause to quit. Affirm the AT, no voluntary leaving, chargeback, employer is a party of interest.
Reverse the AT, voluntary leaving, no chargeback, adequate employer response, employer is PI.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case 2897786, Commissioner Dimerson.
We should affirm the appeal tribunal decision. The claimant was discharged for entering a restricted office at the employer's place of business and thereafter taking paperwork from the office without authorization. The claimant showed that the contents of the paperwork to another employee at the office and hid the paperwork underneath her shirt. The claimant had signed and acknowledged the employer's policy, which dictated that employees who entered or attempted to enter a restricted area without authorization would be terminated on the first occurrence. Since the claimant was aware of the employer's policy and intentionally violated the policy through her conduct, the appeal tribunal decision should be affirmed. Misconduct, no chargeback. In the alternative, the commission should rehear the case to admit the video surveillance footage of the final incident, which led to the claimant's separation. The surveillance footage of the final incident is relevant and material and should be considered before making a decision in this case. As such, we should rehear the case for further admission and review of the surveillance video.
Yes, sir. Go ahead.
Ms. Miller, I would agree to a rehear.
Rehear.
Unanimous vote for a rehear.
Case 2904114, Commissioner Dimerson.
We should modify the appeal tribunal decision. The job separation was initiated by the claimant when she failed to return to work from paid leave. The claimant's reasons for leaving work were related to her attending nursing school. Quitting to return to school is a personal reason and not good cause connected with the work. Although the claimant later added that fear of retaliation from her supervisor was the primary reason for quitting, she did not bring her concerns to the employer. By not providing the employer a reasonable opportunity to address her concerns, the claimant quit without good cause connected with the work. Accordingly, we should modify the AT decision, voluntary leaving, reimbursing employer not billed, sever the adequate response issue.
The decision is not correct. The claimant was discharged by the employer on September 9, 2020, due to excessive absences, resulting from illness of herself and her child. Early statements from the employer and documents provided by both parties confirmed that the claimant was discharged for absences on September 9, 2020. Although the employer later correctly concluded that they should not have discharged the claimant and attempted to rehire her with back pay, this is unrelated to her separation, which had already occurred. As the claimant's absences were due to medical issue, she did not commit misconduct connected with the work. Reverse the AT, no misconduct, bill reimburse an employer, set aside adequate response.
Reverse the AT, no misconduct, bill reimbursing employer, void adequate response, memo to investigate unreported earnings.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case 2904155, Commissioner Alvarez.
The AT decision should be reversed. The claimant provided firsthand testimony that he did not disclose any information about the investigation against him to anyone. The employer had only secondhand hearsay to support its allegations. Additionally, the employer's policies do not prohibit the claimant from disclosing information about this investigation to anyone. The employer failed to establish misconduct by the preponderance of the evidence. This case also should not be granted a rehearing. The employer did not request any witnesses to participate in the AT hearing. We do not even know the identity of any witnesses who might be called. There is no indication at all that witnesses were unavailable for the AT hearing. The Commission routinely denies rehearings for claimants under more compelling circumstances than exist in this case. Reverse the AT, no misconduct, bill reimburse an employer.
We should grant a rehearing in this case to further develop the record regarding the employer's policy relating to confidentiality of investigations.
Affirm the AT, misconduct, reimbursing employer not bill.
I'm going to agree with the chairman.
Majority vote is to affirm the AT, misconduct, reimbursing employer not billed.
Short form dissent.
Thank you, sir.
Case 2911720, Commissioner Demerson.
The appeal tribunal decision should be affirmed. The employer's HR witness testified that the claimant engaged in the unauthorized use of company time. The HR witness came to this conclusion by reviewing camera footage, spoke to witnesses, and reviewed timesheets. In response, the claimant denied any wrongdoing. Since the hearing officer was in the best position to determine the credibility of the parties, the employer's explanation of its investigation process and conclusions should be given greater weight than the claimant's denial. As such, the claimant's conduct constituted work-connected misconduct, and we should affirm the AT decision, misconduct, no chargeback. In the alternative, if my fellow commissioners do not agree, I would also support a vote for the commission to grant a rehearing in this case so that the employer can submit its camera footage, and also to further develop the record in terms of what exactly the claimant was doing or not doing during the final incident.
The decision is not supportable. The employer alleged that the claimant misused company time but did not testify to any specific examples or provide evidence of the claimant's alleged misuse. The employer has not provided firsthand testimony related to the claimant's alleged misuse. The claimant has denied any unauthorized use of company time. The employer has failed to provide evidence of misconduct despite the opportunity to do so. Reverse the AT, no misconduct, chargeback.
Rehear for firsthand witness testimony and video evidence.
We will rehear the case.
Case 2914993, Commissioner Alvarez.
The decision is not supportable. The claimant was physically assaulted by a coworker and former romantic partner, including being slammed into a car and being choked. After the assault, the assailant attempted to leave with the claimant's car keys, eliminating her avenue for escape. The claimants reacted reasonably, in attempting to retrieve her keys by grabbing the assailant's hood. The claimant was scared for her life and merely wished to get her keys so that she could leave. The The claimant has provided multiple witness statements and a police report corroborating her story. No evidence has been presented to indicate the claimant acted as an aggressor. The claimant's actions were reasonably calculated in an attempt to secure her means of escape from an aggressor and cannot be considered misconduct connected with the work. Reverse AT, no misconduct, chargeback.
We should affirm the appeal tribunal decision. No one disputes that the claimant was the victim of an assault. However, once the aggressor was walking away from her, the claimant's actions in physically restraining him and preventing him from leaving violated the employer's policy. Furthermore, such actions could have resulted in further physical harm to the claimant. Thus, because the claimant violated the employer's policy, she mismanaged her position of employment. We should affirm the AT decision. Misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case 2915472, Commissioner Alvarez.
The claimant worked as an independent contractor for a delivery service and was at all times self-employed. Since the claimant is free to return to work at any time, no separation occurred, and the continued claim should be voided. Void continued claim and job separation and overpayment determinations.
We should affirm the appeal tribunal decision. Because the claimant quit her job due to transportation issues, which is a personal reason not related to the work, the claimant quit without good cause. Thus, the disqualification and overpayment are appropriate. We should affirm the AT decision, voluntary leaving, overpayment of $1,553.
Void the continued claim, no overpayment.
Short form dissent.
Yes, sir, Commissioner Demerson. And that was the last UI case pulled for additional discussion, on docket 40. You should have received the UI short form dissent lists on docket 40.
I move we accept staff recommendations on the remaining UI cases on docket 40.
Chairman, I second the motion except for those cases in which I'm dissenting, as reflected on the UI short form dissent list for docket 40.
And I concur with the chairman's motion except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 40.
Motion passes with the exceptions noted.
Thank you.
Thank you. Is there any other order of business come before the commission?
Chairman, I have one thing I'd like to say prior to today adjourning our meeting. I would like to take this opportunity to recognize and congratulate Jamie John. She is leaving us, but moving on to a new opportunity with HHSC to their provider finance division. Jamie has been with the Texas Workforce Commission since 2008, beginning her career in the appeals department, then commission appeals before coming to my office in 2016. We wish her nothing but the best. Today's her last meeting with us here.
Mr. Chairman, I'd like to congratulate Jamie first of all in what she's doing and wish you the best of luck. Thank you for what for the service that you've provided over the years. Secondly, I wanted to recognize Susan Thomas and that team for being recognized last night as the best company, one of the best places to work in the state, and I wanted to just send kudos out to Susan and her team down there in the Belton Temple area.
Absolutely. I wish I'd been better prepared to congratulate Jamie. It's a great opportunity. Any other order of business? If not, I'll entertain a motion to adjourn.
Chairman, I move that we adjourn.
I second that motion.
It has been moved and seconded to adjourn, and we're adjourned.